Ladies and gentlemen, this is Justice Swatanter Kumar, former judge of the Supreme Court of India and former chairman of the National Green Tribunal for India. Today I wish to speak to you all as to the environmental jurisprudence and environmental laws in India. No element of nature, no creatures, including humans, none of us are untouched by the adverse impacts of environmental degradation. We are all suffering harmful effects in our everyday lives, and we have only us to blame. The question that I consider of greatest importance facing not only India today, but the entire globe is, are we taking sufficient measures to prevent environmental degradation in the form of irreversibility, irretrievability, or are we adopting the correct principles of sustainable development? It cannot be denied that there is need for development in all spheres of human life, but that development must confine itself within the limitations that the environmental jurisprudence, settled canons provide, and the regulatory laws of the country provide. In furtherance to its international commitments in Rio and Stockholm, the Government of India presented and the Parliament enacted the laws with regard to air pollution, water pollution, and then finally, in the year 1986, Environmental Protection Act. These were not only primarily the commitments in the international platform that persuaded India to enact the laws with regard to the various fields for environment, but the history of India shows that our heritage, our culture has all through supported and showed different varied methods, mechanisms to protect the environment and ecology. Right from the ancient times, we have looked up on environment, and as most of you may be knowing that in India, the rivers are worshipped, the forests are worshipped, the sun is worshipped. There are special havanas which were organized by different communities for the purposes of cleaning the air. If I take you around about 700 years back, in the Meenakshi temple in the south of India, in Tamil Nadu, there is on the wall two different chakras created, which were published at different times for the purposes of bringing environmental awareness to the people at large. These chakras talk about 3 levels above the sea, 3 levels below the sea, and how those levels should be protected. It talks of ozone layers. It talks of the impact of climate change that was to occur with the passage of time in our societies and the entire globe. In this background and the fact that the Parliament, in furtherance to its international commitments, enacted laws, and the most recent of its times was the National Green Tribunal Act of 2010. This act came upon a specific mandate by the Supreme Court of India that there should be specialized environmental tribunals for protecting and deciding expeditiously the cases relating to environment and protection thereof. It is after that this act was enacted that the tribunal, which had a specialized system of functioning, it had distinguished experts from the environmental fields, be they hydrologists, they be scientists, they may be environmentalists, they may be the engineers, professors, but they had to have an expertise in the field of environment at least for a period of 15 years before they could be considered to be appointed as the technical member of the tribunal. The bench was presided by a judicial member who was expected to be the Chief Justice or a judge of the High Court, whether present or in the past. The chairman of the tribunal was expected to be the former judge or a sitting judge of the Supreme Court of India. The structure of the tribunal was indicative of the legislative intent that it must be kept in mind that the environmental cases are not to be decided like normal cases, but they were expected to be decided with expert input so as to ensure that the orders finally passed by the tribunal were of not only high content in terms of law, but it was also in terms of implementation, keeping in view the available technology and acceptability of the technology for prevention and control of pollution and environmental degradation. Economic growth, it is believed mostly that the same can be achieved through exploitation of environment and natural resources. No doubt it is possible, but will such growth be sustainable? Definitely not. What nations need to work together is for sustainable economic growth, which is more equitably distributed, and such growth is solely dependent on environmental conservation and preservation of natural resources. If we are not able to preserve our natural resources, the results are going to be disastrous. If we must ensure that the conservation of natural resources and their utilization for human good within the limitations specified is the key to a progress, growth which is sustainable. Reckless development, urbanization, or any aspect of human existence which is in contrast to the fundamental principles of environmental protection would and is likely to cause irreparable damage, and therefore would be very, very unfortunate for the generations to come. While I was giving you the background with regard to the environmental consciousness and the environmental regulations existing in the country, probably India is one of the exceptional country which has the common principles of environmental jurisprudence were codified and were made part of a statute under Section 20 of the National Green Tribunal Act. That showed that principles of sustainable development, polluter pays, and precautionary principle or intergenerational equity principle had to be applied by virtue of legislative mandate by the tribunal while deciding cases. It is not something very ordinary. These principles were applied by the tribunal in all cases that it disposed of from time to time. I would be sharing with you certain cases which will demonstrate as to how the advantage took for a combination of expert judicial and technological minds for the benefit of the environmental protection. Under this act, which I think is an act which gives to the tribunal a very wide jurisdiction, and the jurisdiction that is vested in the tribunal had threefold jurisdiction. Firstly, it had appellate jurisdiction, where the various orders that were passed by the regulatory authorities, pollution control boards, forest authorities were made appealable under Section 16 to the tribunal. Then was under Section 14 the original jurisdiction which the tribunal could exercise for the purposes of protecting the environment, and any person aggrieved could approach the tribunal for raising a substantial question of environment in relation to the 7 acts that were specified in Schedule 1 of this act, which means that the environmental acts in our country, there were main 7 leading acts, including, I just said, Environmental Protection Act, Air Pollution Act, Water Pollution Control Act, Biodiversity Act, and the other incidental acts to these primary acts, including the Forest Act, which the purpose was primarily to protect and conserve the forests in the country. All these acts, if any applicant could come and complain by raising a substantial issue of environment, the tribunal was called upon to decide them in accordance with the Sustainable Development Principle. Then it had the jurisdiction with the tribunal, which was kind of supervisory jurisdiction, that the tribunal, in performance of its functions, would ensure that the 7 acts specified in Schedule 1 were duly implemented for protection of the nature, natural resources, biodiversity, water, air, etc. What is of greater significance is that Section 17(3) of the Act embodied in itself the principle of strict liability. It was clearly indicative of the fact that the onus to prove lay on the person who was carrying on an activity which was likely to pollute or was actually polluting. The applicant had a primary onus, and the heavy onus lies on the basis of the principle of strict liability upon the industry, other persons who were carrying on business activities, but were ultimately adding to the pollution. It is in this legal principles that the tribunal had been acting. One of the very widely deliberated upon issue in our country that I would bring to your notice is that initially the cases of environmental protection were being dealt with by the Supreme Court of India, high courts, who had taken very emphatic decisions to protect the environment. Then the primary burden came upon the tribunal to handle the cases with regard to these environmental matters. The 3 stated principles in Section 20, Sustainable Development Precautionary Principle and Polluter Pays Principle, have a very demonstrable interrelation between themselves. And there are cases and cases dealt by the tribunal where all these 3 principles had to be dealt with together and given effect to while passing orders, that none of these settled doctrines of environmental jurisprudence ever got a setback. The cases were of variety. There were cases relating to mining, cases relating to unauthorized constructions, cases relating to water pollution, river pollution, covering of the wetlands, deforestation, and even to the extent of serious air pollution. All these cases were dealt with effectively by the tribunal, even while invoking the principles of consultative process of the stakeholders. All stakeholders were involved because the tribunal believed in dispensation of justice, environmental justice by it, that it is important for us to know the views of the executing authorities, including the government, before we could pass any final order. Keeping that factor in mind, consultative process paid great dividends, as the tribunal was able to pass orders which were implementable, because I feel that the test of a good judgment is its capability of its being executed and its acceptance by the public at large. Environment in any country, not exceptionally as in India, is a matter where everybody has to be involved. It's the state, executive, politicians, courts, and the common man. Once all of them will get together, then alone you can achieve the object of fulfilling your obligation of maintaining the environment in its proper perspective. An interesting feature under the Constitution of India, interlinked with the principles stated in the National Green Tribunal Act of 2010, is the environmental protection triangle as spelled out under Article 51AG of the Constitution, read with 43A. One of them provides as directive principle for the stating that the state government must protect its natural resources, environment, and do everything possible within its means. It places an obligation upon the citizens to ensure that they protect the environment, natural resources, and perform their constitutional duty without any hesitation. Cumulative impact of these two articles led to the Supreme Court deciding that Article 21 of the Constitution of India, the Fundamental Right chapter, included right to life as a right to decent and clean environment. Thus, that became the environmental protection triangle, which is of great constitutional value and is being enforced by various courts, the tribunal, in the various judgments that are being passed by the tribunal from time to time. I would deal with one of the cases that is relatable to Rohtang Pass. It's a pass at the height of 17,000 feet from the sea level. The glaciers, various glaciers meet at this path. It's a great tourist spot, and the only road passes through this pass for a place called Leh and Ladakh from rest of the part of Himachal Pradesh and from the other side from Srinagar. Now, the question that arose was that because of carbon emissions and the pollution being caused by vehicles, the waste that was being thrown by the visitors, by the tourists, the commercial activity that was being carried on had a very severe impact, adverse impact upon the entire glaciers as well as on the pass. The glaciers were stated to be reducing by 1 meter per year and had considerably lost. Another very serious damage to this beautiful spot of nature was that there was very high scale deforestation done for the commercial activity. The people, for gaining some money, fell thousands and thousands of trees around this area. The application that was filed before the tribunal, as well as the tribunal took suo motu action, there were directions issued for regulating the vehicles going up to Rohtang Pass. Complete scheme was formulated for the purposes of afforestation, because plantation at this height is not easy. So the trees were to be grown in the nurseries and then taken up and maintained there at the height going from Rala to Rohtang Pass. Other was regulating the commercial activity. Next was with regard to ensuring that there was no carbon emissions out of emissions from the vehicles as well as from the scooters, snow scooters that were being driven on this. Now, the conflict was the livelihood of the people who were working and their right to carry on business. Therefore, the principle of sustainable development was applied. Directions were passed for precautions which were required to be taken, regulation of vehicles, no waste to be thrown, limited restricted activity to be carried on, and an eco-friendly market was directed to be created at a lower height, and people were directed to be provided with the employment. A ropeway was directed to be constructed, and it was made necessary for the company constructing the ropeway that the local people who had lost their jobs, they should be employed in preference to others. Now, this will show you that there was a precautionary principle directions issued, sustainable development was permitted, and there was complete responsibility laid on the people who had been polluting for years to impose environmental cess or environmental compensation in terms of section 15 and 17 of the Act. This is the kind of gamut of jurisdiction that was being exercised by the tribunal. The orders of the tribunal were challenged in the Supreme Court of India, and the Supreme Court declined to interfere, as it was brought to the notice of the court that there was exceptional directions needed to meet the situation and to protect the ecology and natural resources of that place. If at that rate the glaciers were permitted to diminish, probably they would practically be ending and causing a great disaster. There was change in climate. The snow, which used to be more than 10 feet on those hills in the winters, reduced to 4-5 feet. It caused water pollution. Therefore, directions were also issued for protecting the water. This is how a balanced view was taken while ensuring that the people do not suffer unnecessarily and they at the same time do not cause irreparable damage to the natural resources as well. The other case that I would like to mention is Samir Mehta's case, which the tribunal decided, where a ship was dumped in the territorial waters next to Bombay. Now, this ship, which started from Indonesia, was given clearances in a way which was not fair at the face of it, and there was sufficient evidence before the tribunal that the ship was not seaworthy when it was sailed. It carried something like, I think, 1,000 metric tons of coal. It was brought there. On the way, it had difficulties. There were emergent help rendered. Its mechanisms failed. However, it was brought, and 21 nautical miles from Bombay shore, it was sunk. Oil spill caused tremendous pollution to the sea life, the biodiversity, the aquatic life, and the end of the shore, where people were having oils all over this. Now, in this, the tribunal, referring to the various conventions and treaties, there were as many as 9 of them. Can't refer to them in detail now because of the time. And ultimately, there was a crucial question before the tribunal whether dismantling of the sea itself would cause a greater pollution than if it laid the earth. An expert body was appointed, and then it was left to the authorities concerned to direct that the ship should be broken or left permitted to lay as it is. Besides imposing 100 crores as compensation, environmental compensation upon the owner of the ship, it was also directed that 6 crores were payable by the consignee of the coal, the company in India, and various directions were passed where the guard authorities, the Pollution Control Board, the Submarine and Merchant Shipping Act provisions were invoked, and directions were passed for clearing the remnant of the oil spill and also to take all precautionary steps for ensuring that the ship which lay at the bottom of the sea did not become a continuous source of pollution. This is few of the directions were passed. Now, we had to keep in mind that any order or direction of the tribunal is not passed which will ultimately result in further pollution. So, the recommendation of the committee that the ship should be permitted to lay where it was accepted, but a principle which was of international significance and stated that in terms of the treaties, nobody or no country has any right to create and take a ship and dump in the territorial waters of another country, because the treaties, including the United Nations Convention, had clearly said that pollution by ship should not be permitted in the territory of another country. The tribunal has been discharging various functions and performing its duty of giving inexpensive, expeditious, just environmental justice to the people at large. Its functioning in the country has created national awareness of environment. It has evoked the feeling of protection of natural resources even in the young generations. I think we need to follow this in various parts of the world to ensure that the environment is protected, so that the nature, which we better care for it, because we need nature and nature doesn't need us. Thank you all.